an employee can take you to an employment tribunal regardless. I mean, you can be super fair, you actually may have followed all the processes, all the procedure, etc., and still the employee decides to take you to an employment tribunal. And you may go, that's not fair. Well, that's the way that it works. Nothing is preventing an employee to take you to an employment tribunal. Of course, there are some steps and measures that you can take in order to get this claim struck out. So, for example, you can get into a negotiation with the employee to settle it. But there is nothing that can prevent an individual to submit a claim to an employment tribunal. If they decide to go ahead, they will go ahead. So if you hear a professional telling you, I can assure that this person will not take you to court if you follow what I say, I would run a mile. You never know what is going on in an employee's mind. What you can do is actually to be fair, to act in a consistent way, and basically to identify what are the categories, what is the category in which the situation, the problem that you're having is falling into, and act in a fair way. Because if an employee decides to take you to an employment tribunal just because they want to give it a shot, I mean, there are plenty of employees that just want to make money, so say, I just submit a claim and they will settle and I just get some money. Well, no, because if you're being fair and actually being a reasonable employer, if they submit a claim, the possibility that you have to get it struck out, or actually that the employee is going to succeed genuinely, goes down to a very, very, very small amount. So basically you can minimize the risks by acting in a fair way. So, as we said, one of the main problems that employers have got nowadays, coming out from surveys, I mean, there was a survey that was published by a barrister called Daniel Barnett just last week, and they said that one of the main issues, one of the biggest fears of an employer is to be taken to an employment tribunal. But not everyone actually can take you to an employment tribunal. Ah, yeah. So who can actually claim for unfair dismissal? Well, we saw what are the 5 reasons for dismissal. Unfair dismissal basically is when the employee is saying, I have been dismissed, for example, not for one of these 5 reasons, or the process that was followed was absolutely appalling. This is to generalize it. But not everyone can take you to an employment tribunal. In order to take you to an employment tribunal, the person has to be an employee. So, for example, I work as a self-employed person, so when I go to my clients, I am not on their payroll. Basically, I've got my own company, I've got my own payroll, and so on and so forth. I cannot take them, for example, to court for unfair dismissal, for the simple reason that I am not an employee. Again, this is very high level, so there is a little bit of a grey area, but as a rule of thumb, if the person is, for example, self-employed, it's a contractor, they cannot actually sue you and basically take you to court for unfair dismissal, for the simple reason that they are not employees. Agency worker. Agency worker basically is actually a bit of a nightmare nowadays, because they have just changed the legislation in October 2011, and agency workers basically are individuals that are basically employed or by the agency, or they can be employed by the end user, or neither. So again, when you got an agency worker, it is not said that they are entitled to take you to an employment tribunal. This is actually an area of the law that is going to be tested over the next few years, because the legislation has just changed. So if you got an agency worker, alarm bell have to go on and saying, hang on, is this actually our employee or not? Up to a few years ago, if someone basically was, well, actually not too long ago actually, if someone, for example, was 65, over 65, they didn't have the right to claim unfair dismissal. This upper limit is being taken away. So now, basically, there is no more limit in terms of the upper age to take you to court. So even if someone, for example, is 66, they can still claim unfair dismissal. So basically what you want to check is fundamentally the person is an employee. And can they actually claim unfair dismissal regardless? So they've been with you for 2 weeks and they take you to court for unfair dismissal. Can they do that? Potentially yes, but only in some circumstances when there is an exception. Let's start with the basics. So you will have to make a distinction between the employees that have been hired before the 6th of April 2012 and those who have been hired afterwards. Those that have been hired before the 6th of April 2012 can take you to an employment tribunal for unfair dismissal only if they've been with you for at least 1 year. So they got to have, they have to, it's called continuous length of service. So it means they have to be continuously employed by you for at least 12 months. If the employee has been been hired by your company, so basically you have this person on your payroll after the 6th of April, in order to have the amount of service required to claim unfair dismissal, they have to be with you for at least 2 years. This is actually a new change that was introduced by the new coalition in an attempt basically to reduce the number of claims and basically to make it harder for an employee to claim unfair dismissal. Whether it's going to be useful or not, to be honest, we would have to see. I mean, if you check my blog, actually, you would see what are my ideas on the topic. So if, for example, you hire someone on the 5th of May 2012 and this person on the 6th of July claim that they have been unfairly dismissed, well, it's very unlikely that their claim will succeed, unless it is an automatic unfair dismissal. So there are situations, but these are exceptions, whereby an employee has the right to claim unfair dismissal regardless the length of service. So for example, if you dismiss someone because they make you aware that they are pregnant or they are on maternity leave, and that's the reason for dismissal, it's automatically unfair. So regardless whether they've been with you for 3 weeks, 2 months, they can still take you to court for unfair dismissal. If, for example, someone makes a request to work flexible working, so they have a child and basically they ask you, listen, do you mind if, for example, I work just 4 days or instead of 5? Or, for example, they ask you to work part-time. These are all reasons that will lead to an automatic unfair dismissal. For example, someone is a fixed-term employee. It's not unusual, and again, there is a lot of misconception about fixed-term employees. I mean, a lot of times they are not given the rights because they are considered sort of Class B employees, which is appalling. And it's not unusual, basically, for fixed-term employees to actually claim that they've been treated in a different way compared to the permanent employees. For example, they have not received the right amount of benefits they are entitled to on a pro rata basis. If you are an agency worker, if you assert a statutory right, basically there are a lot of reasons that would not require the employee to have a specific length of service. So when you decide to take action, you have to be very, very careful that you are doing it for the right reason. So for example, if you want to discipline someone because they turn up for work late, that must be the reasons why you're disciplining them, not because, for example, someone has asked for part-time working and you say, oh, you know, I actually start disciplining you, I get you out so that basically you will be gone. No, that's actually not the real reason. There actually will be an automatic unfair dismissal. So you always have to be careful what